Appearing there from the jail.
This is Corey Price, Your Honor. Michael Scholl is there.
Oh, okay. Corey Price.
Yes, sir.
All right. Case number 22 CR 47, State of Ohio versus Corey Leon Price. Mr. Price is appearing from the jail by Zoom. His attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. This matter is set for a plea, and Mr. Kirk, you and your client both stipulate to the hearing being conducted by Zoom rather than an in-person appearance in the courtroom.
Yes, Your Honor.
And you're okay with that, Mr. Holler, or Mr. Price, I'm sorry.
Yes, Your Honor.
All right. Mr. Price is charged with aggravated trafficking of methamphetamine, aggravated possession of methamphetamine, both second-degree felonies, and aggravated possession of methamphetamine, a fifth-degree felony. There was a pretrial on this back in, earlier this month on the 4th. There's a final set for the 1st of February and trial set for the 23rd. The matter was set today for a plea at the request of the parties, and I have received a plea agreement, Mr. Price, which indicates you're going to withdraw your not guilty plea, plead guilty to count 1. I'm going to hold this up to the camera to show you that has your case number and name. You recognize that form?
Yes, Your Honor.
And on page 3, there are signature lines. There's a sentence about halfway down the page that says, "I enter this plea voluntarily." Right below that is a signature. It appears to be Corey Price. I'll hold that up to the camera as well. And is that your signature there?
Yes, sir.
I'm showing you. When did you sign this document, Mr. Price?
I believe it was Monday.
All right. And before you signed it, did your attorney go over it with you and explain everything to you and answer any questions you had?
Yes, Your Honor.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case is a sentencing hearing?
Yes, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you are pressured or rushed in any way into doing this?
No, sir.
And did you enter into the agreement to plead guilty voluntarily?
Yes, Your Honor.
All right, now, as indicated earlier, the agreement is you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1 of the Ohio Revised Code, a second-degree felony. It states on page 1 that you understand that the maximum penalty for that could be 8 years in prison. The minimum is 2. And the judge is the one who selects one of those numbers as the minimum sentence, which is mandatory. All of that must be served. There could be no community control, probation, judicial release, early release of any sort. Under the law, the Department of Rehabilitation and Corrections does have the authority to extend this sentence in a case of this nature for up to 50% of whatever was ordered by the judge. And so because of that, that means that if the court imposed the maximum of 8 years mandatory, that would have to be served. And then at the discretion of the DRC, it could be extended for an additional period of up to 4 years to make it a maximum of 12 years. Do you understand that?
Yes, Your Honor.
Now, there's also a fine available of up to $15,000, mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction besides this? Are you currently on probation, community control, parole, or post-release control for a felony?
Parole.
Okay, and where's that from?
Highland County.
The PRC?
He's on PRC, Your Honor. I think there was a notice filed in the file.
Okay. Yes, here it is. December the 9th it was filed, and it says that you have 778 days remaining as of December 9. So today is January the 20th. So from December the 9th to today, we'd have 22 days to be deducted and another 20 today, which make 42 days. So that means that you still have 736 days of PRC remaining. Now, under the law, if you're convicted of this offense, then and you commit offense while under PRC, then the law provides that the court can impose an additional sentence for committing that offense while under post-release control of 1 year or whatever time is left on the post-release control. And since 746 days, I think you said, 36 days is what's left, that is more than a year, so that would be the amount that would be imposed in addition to whatever sentence was imposed for this offense. Do you understand that?
Yes, sir.
All right. Now, under the law, once if you plead guilty, you will be sentenced to prison, as I said, because it's mandatory. And once you complete the sentence imposed by the court, it is mandatory that, and any additional sentence may be ordered by the DRC. It is mandatory that you be put on post-release control, on this case, for a period of at least 18 months, up to a maximum of 3 years. And that means you'll be supervised by the parole officer appointed, assigned to you by the Adult Parole Authority. And if during that period of time they determine that you have failed to comply, they can return you to prison to serve an additional period of time as a sanction of up to 9 months for one violation or more, but up to a maximum of half of the prison term for all the violations. But again, if you commit a new felony while under post-release control, as just indicated to you, you could then also be sentenced to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And again, that must be served consecutively to the sentence of the new case. You understand that?
Yes, sir.
Right now, the charge in this case alleges that on or about July 28, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, an amount equal to or exceeding 5 times the bulk amount, but less than 50 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge. You're facing the mandatory 2 to 8 years set by the judge, up to an additional 50% added by DRC if they decide to do that. Fine of $15,000, mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. Now,
Your Honor, I apologize to interrupt. As you read that, I realized there's an error in count 1 in the code section.
okay,
It says 292511. It should say 29250381.
I'm looking at the form. It says 292503A1.
Okay, I thought you were reading from the indictment.
Oh.
I'm looking at page 2 of the indictment.
Yeah, I did. Oh, okay, you're right. The indictment. Okay, it's okay on the face, but not on there. Okay, all right. So you're moving to amend that.
That's correct, Your Honor.
All right, Mr. Kirk, any objection?
No objection. All the other documentation the state provided, including the face sheet and the indictment, have the correct section, so
Yeah.
we were on this.
Well, pursuant to criminal rule, an error in a designation of a statute is a basis for correction of amendment of an indictment, and particularly since the language is in the correct statutory section, and it's also correct on the face sheet as well as in the plea form. All right. Thank you. All right. Now, Mr. Price, have you discussed the nature of this charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
And you understand the possible penalties for this offense?
Yes, Your Honor.
And you understand what it is the state has accused you of having done and when, where, and how they alleged you did it?
Yes, Your Honor.
And are you satisfied with your attorney's advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to make you plead guilty today?
No, sir.
Or any other time that they threatened you?
No, sir.
Okay. Now, at the bottom of page 2, there's several lines printed in bold and underlined, which define the specific substantive terms of the agreement, so I'll read those into the record at this time. Defendant shall enter a plea of guilty to count 1. State will dismiss remaining counts. State and defense jointly recommend 2 years mandatory incarceration consecutive to the time remaining under post-release control supervision. Defendant agrees to pay back by money in the amount of $375 to the Highland County Task Force. Defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Price, the matter of sentence is up to the judge. And so even though there's a recommendation from both parties that the minimum should be imposed, if you plead guilty or if you're found guilty at a trial, I don't have to follow that recommendation. I could impose any sentence that I think is appropriate under the law based upon the information submitted to me. Do you understand that?
Yes, sir.
Now, Mr. Price, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession in this state?
No, sir.
All right, now you have certain rights you must understand before I can accept your plea. First, you do have a right to have counsel. Mr. Kirk was appointed to represent you. Now, that wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. And so if you decide that you do not want to plead guilty, he'll continue to defend you, represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution and law, Mr. Price, you have a right to a jury trial on this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After those 12 are selected, the evidence would be presented and they would be instructed on the law. And then that jury of 12 persons would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. And in that case, you have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it's the judge hears the evidence, the judge applies the law, and the judge decides whether or not the state proves your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront the witnesses against you and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, at any time, by any person in the proceedings, and in fact, no one's even allowed to talk about it, with one exception. If there's a jury trial and you do not testify, the judge doesn't instruct the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
All right, now under the Constitution, Mr. Price, you are presumed innocent until proven guilty by the state of Ohio on all of the essential elements of the offense charged. So, what that means is that you're not required to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty, Mr. Price. That plea denied the allegation, denied that you committed any crime, and it exercised or invoked any of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegations in the indictment, admit that it is a crime, count one that is, and admit that you committed that crime in count one. And that plea will waive or give up any rights that you, all the rights that I've explained to you, I should say, except your right to an attorney, because you always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty will waive or give up your right to a jury or court trial. It'll waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. It'll waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It'll waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And it'll waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, and it waives or gives up any right to file an appeal you think you could have had up until this point in the case. Now, if you should get the maximum sentence from the court, or under other certain limited circumstances, an appeal could be filed, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, now, Mr. Price, do you have any questions about the charge and the possible penalties in count one?
No, Your Honor.
You understand them,
Yes, sir.
including the PRC time?
Yes, sir.
Okay. Have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
Have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes, sir.
All right, now, I didn't say this at the beginning, and I should have, and that is that since you're not sitting in court next to your attorney, if you have any questions you need to ask him or anything you'd like to talk with him about before we go any further, I can put you and him now into a breakout room where the two of you could talk without anyone else being present. The deputy would leave while that's happening, and then you would be able to talk confidentially without anyone else being involved or listening. Do you need to talk with him about anything?
No, sir.
All right, do you have any questions about anything I've explained to you here this morning?
No, Your Honor.
All right, then is it your decision to go forward and enter a plea of guilty to count one according to the terms of the plea agreement that you've signed?
Yes, sir.
Okay, then as to count one, which alleges that on or about July 28, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, in violation of Section 2925.03A1, which I've written in on the indictment to correct that, a first-degree felony carrying a mandatory prison term of between 2 and 8 years set by the judge, a maximum of up to half being added by the by the DRC to the sentence that may be imposed by the court, a fine of $15,000, a mandatory fine of $7,500, and a possible license of 6 months to 5 years suspension, plus PRC time of additional 736 days consecutive to the sentence that could be imposed by the court. How do you plead?
Your Honor, I think you referenced it as a felony 1, it actually felony 2.
Oh, okay, felony, yeah, I'm sorry, felony 2. I did recite the correct penalty, but yeah, it's a felony 2.
Yes.
All right, thank you. How do you plead?
Guilty, Your Honor.
All right, thank you. All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights pursuant to Criminal Rule 11, and therefore his plea of guilty to count one is accepted as amended to correct the statutory designation. Counts 2 and 3 are dismissed. Now, inasmuch as this is a mandatory prison term required by law, and there is a joint recommendation of sentence, the court doesn't believe there's a need for a pre-sentence report, and so I will go ahead and proceed with sentencing forthwith. Anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
Okay. Ben, you're getting the jail time credit there. All right, Mr. Kirk.
Thank you, Your Honor. This is my client's second felony. The first felony was back in 2017. He's been very cooperative with me. That's why we're here pleading before even the second pretrial. And then even though he didn't plead guilty to it, count 3 involved possession and charge, and he was very cooperative with law enforcement. Owned up to the fact that it was methamphetamine he had on it and that it was his. He, in this case, appears from speaking with him and looking at the discovery, he's certainly culpable and did plead guilty. He was somewhat of a middleman in the case. and the amount of money he received out of the transaction was, he was suffering from drug addiction at the time, and he went and bought food with it. That's what he's reporting to me, and I know that doesn't excuse it by any stretch, but he was definitely not making a profit off of this in any way. And furthermore, this normally they'll have several buys off of an individual. We'll see, multiple count indictment for trafficking. In this case, we had the one buy for trafficking. It didn't appear to be something my client was engaging in on a regular basis. So would ask the court to follow the plea agreement. And then as for the PRC time, I've advised my client the court's policy is typically to impose it. I would ask the court to consider not imposing it, but understand if the court does.
All right. Thank you. Mr. Price, anything you would like to say?
No, Your Honor.
All right. Well, yeah, it's order and judgment of the court then that the defendant being is hereby sentenced to the Correction Reception Center in Orion, Ohio for a period of 2 years, which will be a mandatory sentence as required by the law, with the possibility of that being extended by DRC of up to for an additional 1 year for a maximum of 3 years. You were arrested on the 7th of December, is that correct?
Yes, Your Honor.
All right. So according to that, then you have 46 days of jail time credit as of today, and then you'll get credit from here on forward by the DRC for for the days that you are in custody until you're delivered there. Now, it's also ordered that you be sentenced to serve the 736 days of time remaining upon your post-release control, because this offense was committed while you were under post-release control for that previous offense. And by law, that's required to be served consecutively to the sentence in the new case. Now, upon completion of your sentence, Mr. Price, the law requires that you be put under PRC again, post-release control supervision, for a period of at least 18 months, up to a maximum of 3 years. And if during that period of time you violated those conditions, they can return you to prison, make you serve an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. And again, if you commit a new felony while under post-release control, as is the case here, then in addition, whatever sentence could be imposed for committing that new felony, the judge in that case could sentence you to an additional period of a year, or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. You're also ordered to pay the court costs, which judgment granting execution is ordered. If you can't do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, then you could be permitted to do community service in this county and be given credit for each hour you worked at an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. It's also ordered that you make restitution to the Highland County Task Force in the amount of $375. That's to be paid through the victim witness restitution escrow account, and you'll pay any fees associated with that. Yeah. Now, has there been any change in your financial circumstances since you had counsel appointed?
No, Your Honor.
All right, the court then will waive the mandatory fine, find that there's no possibility that you'll be able to pay that now or in the near future, and the court will not impose any driving suspension either. All right, is there anything further from counsel?
No, Your Honor.
All right, then you're remanded back to custody for conveyance to CRC, Mr. Price. Thank you.
Yes, sir.
All right, are you Michael Schaller?
Yes, sir.
All right, this is case number 22 CR 216, State of Ohio versus Michael Schaller. Mr. Schaller is appearing by video from the Justice Center. His attorney appearing from his office is Mr. Dennis Kirk, and appearing on behalf of the state is Assistant Prosecuting Attorney King. This matter was set for a plea to request the parties. We had a pretrial on the 9th. and a final pretrial is set for February 1st, with the trial being the 23rd. Now, Mr. Kirk, are you and your client both in agreement this matter can be conducted by video rather than him appearing personally in the courtroom?
Yes, Your Honor.
And you're in agreement with that, Mr. Schaller?
Yes.
All right. Now, since you're not in the courtroom next to your attorney, if at any time during this hearing you would like to speak with him privately, then you can just tell me, and then I can put you and him into a breakout room where it'd just be the two of you on the screen talking. No one else will be able to see or hear you, and the deputy would step out of the room while that's taking place. Okay?
Yes, sir.
All right. Now, Mr. Schaller is charged with illegal conveyance and aggravated possession of fentanyl-related compound, both third-degree felonies, and aggravated possession of methamphetamine, a fifth-degree felony. I have been provided a plea of guilty form here, Mr. Schaller, which indicates you're going to plead guilty to counts 1 and 3. I'm going to hold this first page of this agreement up. It's actually a 3-page agreement, but the first page I'm going to show has your name and case number and plea of guilty form. Just want to make sure that you do recognize that document. Do you recognize that document? Okay. Now on page 3, about a third of the way down, almost halfway down, there's a sentence that says, "I enter this plea voluntarily," and right below that there's a signature, M. Schaller, a signature of defendant. And I'll hold that up to the camera. And is that your signature there?
Yes, sir.
Okay, now I see some writing right next to that. Is that your handwriting there?
Yeah. Yes, sir.
All right. All right, I'm going to read this just so I understand what it means. On grounds to cooperate with prosecutors, deal to be in court this week of 1/16/22 to resolve as quickly as possible. Okay, so you wanted this just to be done quickly, that's what you were saying?
Yes, sir.
Okay, all right. So that language doesn't mean you're not agreeing to this, it's just something you were giving a message to try to get this matter expedited?
Yes, sir.
Okay, all right. Now, Mr. Schaller, when you signed this, then when did you sign this agreement?
It's on that Monday.
Okay.
Last Monday.
All right. And when you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did your attorney explain everything to you before you signed this, answer any questions you had?
Yes, he did.
And did you have enough time to fully consider this matter before agreeing to enter into this agreement?
Yeah.
And do you still want to go forward with this agreement?
Yeah.
All right, and did you enter into the agreement, and are you entering into it today to plead guilty voluntarily?
Yes, sir.
All right, now the agreement, as I said, states that you're going to plead guilty to count 1, illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility under section 2921.36A2, a third-degree felony, and count 3, aggravated possession of methamphetamine under 2925.11 of the Higher Revised Code, a fifth-degree felony. It further states that you understand that the maximum sentence on count 1 is 36 months. The minimum would be 9 months, and there's certain levels between those two ranges. There's a fine available of up to $10,000. Count 3, there's a possible maximum sentence of 12 months, minimum of 6, and any number in between those two, a $2,500 fine, and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, under the law, if you're convicted of both of these offenses, the court can sentence you to prison and on each, and those sentences can be ordered to be served consecutively, meaning one after the other. So that means that the maximum sentence, count 1 being 36 months and count 3 being 12, that's 48 months. So the maximum sentence that could be imposed would be 48 months in prison. Do you understand that?
Yes, sir.
Other than these charges, are you facing any felony charges anywhere else?
No, sir. I haven't had a felony in 13 years.
Okay. So you're not on probation, community control, post-release control, or parole?
Yes, sir. I've been in prison since 2019.
Okay.
I've been out since 2019.
All right. Now, under the law, Mr. Schaller, if you are convicted of these offenses and sentenced to prison, once you complete the prison term, the Adult Parole Authority could, at their option under the law, decide to put you under post-release control supervision, called PRC, for a period of up to 2 years. They don't have to, but they can. But if they do, you'll be supervised by a parole officer on the terms they set, because the court's not involved with that. And if during that period of time that you're under supervision, they determine that you've not complied, then they have the right under the law to return you to prison to make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever prison term was imposed for all violations. But if there's a new felony committed while you're under post-release control, then in addition to whatever sentence the judge in that new case could impose upon you, that judge could also sentence you to an additional period of 1 year or whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. And that sentence could be ordered to be served consecutive, or would be ordered to be served consecutive to any sentence imposed in the new case. You understand that?
Yes, sir.
Now, under the law, these are not mandatory prison offenses, and so the court's not required to sentence someone convicted of these offenses to prison. It could impose what's called community control or probation. It means that you'd be supervised for a period of up to 5 years by a probation officer under terms set by the court. And if that probation department felt that you were not compliant during that period of time, they would notify you in writing, serve a copy on you, give it to the court, a copy to the court, and then you would have a hearing, and you would be entitled to have an attorney at that hearing. And if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to the prison for 48 months and fine you $12,500. You understand that?
Yes, sir.
All right, now the indictment in count 1 alleges that on or about February 21st of this year, of last year I should say, 2022, in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Highland County Justice Center, or okay, I'm going to not read the rest of it, it's not applicable, a drug of abuse as defined in ORC 3719.011, to wit, a fentanyl-related compound, in violation of section 2921.36A2 of the Higher Revised Code. So that's the charge of the illegal conveyance, third-degree felony with the penalties I described earlier. Count 3 alleges on or about February 21, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of section 2925.11, the Revised Code, and that's the 5th-degree felony with the penalties I just described a short while ago. Now, Mr. Scholler, do you understand what it is you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged you did it?
Yes.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of the trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
I really want to go forward with it today.
Pardon me?
I just want to go forward with it today.
Okay, but are you satisfied with Mr. Kirk's representation?
Yeah.
All right. Have anyone, well, are you under the influence of any types of drugs or alcohol at this time? Has anyone threatened you to make you to plead guilty here today?
Yes, sir.
Now, on page 2, there's about 3 lines of print in bold and underlined that reads as follows. Defendant shall enter a plea of guilty to count 1 and count 3. State will dismiss count 2. State defense jointly recommend 18 months on count 1, consecutive to 9 months on count 3. Is that your understanding of the agreement? Has anyone promised you anything other than that to get you to plead guilty here today? Now, do you hold any license or certification from any state governmental agency for any occupation or profession?
Just tattoo artist.
Okay. Is that license valid at this point?
I'm not sure. Right?
Okay.
I haven't even been utilizing it, man.
All right. Well, under the law, the reason I asked that, under the law, the clerk is required to send a notice of a felony conviction to any state agency that has issued any license or certification. So, that will be done. I don't know if it means anything. We're not saying that they should do anything. It'll be up to them. And if their license expired, it won't matter. But that's the reason I asked that question.
Okay.
All right. Now, you have certain constitutional rights. Misunderstand, Mr. Scholler. Before I can accept this plea, you have a right to counsel. I appointed Mr. Kirk to represent you, not to simply work the case out, but provide any defense that might be available to you under the law. that you would like him to provide. So, if you decide you don't want to plead guilty, he'll continue to defend you and represent you, including a trial if that's what you would like to do. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Scholler, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury on your trial date. After those 12 are selected, the evidence will be presented, and that jury would then have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved the charge against you. Excuse me. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Scholler, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. Excuse me. What that means is that the witnesses against you have to come into court and testify in public in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
All right, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Scholler, you have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter at any time, including the trial. So the prosecutor couldn't make you take the stand, the court can't make you testify, no one can, it's up to you. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way, at any time, by any person in the proceedings. And in fact, no one's even allowed to talk about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to show you're not guilty. The burden of proof is upon the state to prove that you are. In fact, under the law, you don't have to put on any evidence in your own defense whatsoever. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the two offenses charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally, Mr. Scholler, you entered a plea of not guilty to the indictment, denied all the allegations, denied you committed any crime, and exercised all the rights that I've just described to you. If you change your plea from not guilty to guilty to counts 1 and 3, that's the opposite of the not guilty plea. The guilty plea admits the allegations in those 2 counts, admits that they're a crime, that you committed that crime in each count, and that plea would waive or give up all of the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea is, but without exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witnesses against you and to cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Again, it would waive or give up your right to confront the witnesses against you in open court and cross-examine them through your attorney. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove your guilt on either charge. And waives or gives up your right to file an appeal and any alleged violations of your rights you think could have happened up until today. Now, if I sentence you the maximum sentence, or under the certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. And also, again, if I didn't say it, you would be subject to being sentenced immediately by the court. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Scholler?
Yes.
Now, do you have any questions about the charges or the possible penalties? You understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand it? Have any questions about the constitutional rights I've explained? You understand those? Do you have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
Yeah, I understand.
Now, is there anything you'd like to speak with your attorney about before we go any further?
Yeah, if I can have 1 second.
All right, I'll put you and him into a breakout room. There'll be a button that says join breakout room, and then when you're done, you'll have to click a button that says leave meeting, and then you'll have to rejoin. And the deputy will step out there while you're in the meeting with your attorney.
Okay, thank you.
they changed it, and I don't know why they did that, but yeah, there's supposed to be a button that just says leave breakout room,
Right.
not meeting, but apparently you can't find that, so anyway. All right, we're back on record then. Now, are we gonna go ahead and go forward, Mr. Kirk?
Yeah, based on my client's statements, he had some questions, which I did answer for him, and he advised me he does wish to proceed.
Okay, is that correct, Mr. Shoulder?
Yes, sir.
All right. Now, as to the charge then in count 1, which alleges that on or about February 21, 2022 in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, Highland County Justice Center, a drug of abuse as defined in ORC section 3719.011, to wit, a fentanyl-related compound, in violation of section 2921.36A2, the Ohio Revised Code, the charge of illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a third-degree felony carrying a possible prison term between 9 and 36 months in the increments provided by law, fine of $10,000. How do you plead?
Guilty.
As to count 3, which alleges on or about February 21, 2022, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying a possible prison term between 6 and 12 months, and a fine of $2,500 and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept and order filed. Defendant is found guilty of counts 1 and 3. As charged, count 2 is dismissed. Now, inasmuch as there's an agreed upon sentence, and I did take a look at the state's compliance with discovery during the break while counsel was consulting with Mr. Scholler. He does have several previous felony convictions and incarceration, so the court is going to go ahead and proceed with sentencing. Anything from the state?
Only was contained in the plea agreement, Your Honor.
Mr. Kirk?
Thank you, Your Honor. Would note my client has cooperated in this matter. Actually, as you noted on the plea form, we wanted to expedite this and get this taken care of as soon as possible. He was, at the time of the indictment, upon his arrest at a treatment center, Recovery Works in Columbus, so he's got some drug addiction issues that he's been dealing with, and that led to the violations here. So would ask the court to consider those factors and then follow the joint recommendation.
All right, Mr. Scholler, anything you'd like to say?
Yeah, I've been trying to, address my, addiction problem for the past years since this has happened. I've actually progressed a lot, started using my life together. I haven't had a felony in 13 years, which says a lot, but, I've been trying to build a piece of my life together, build it for my son, who's 6, and dismiss custody hearing for him, which I've been working on for years. I've had a couple of hiccups in the past 5 years, but I've been clean for the most part. I've accumulated a lot since then, and this mistake right here was a year old. It's like set me back so far, caused me some losses that I put myself in 2 state hospitals last year and 3 different treatments because, as well as I do, all treatments ain't for everybody. So I'm going from treatment, find the right one for me. I finally found a little groove that I get in that really actually, get to the root of the problems I was doing. So if you take that into consideration that, I ain't the same guy I used to be by far. My penitentiary numbers were back to back, but like I said, I haven't caught a felony in 13 years. And I've been out of prison since 2019, which says a lot. And having this hiccup I've had, man, I've never had no breaks, but, hopefully, you just find it, like, there's some understanding. That's all I'm asking.
All right. Was the judgment order of the court that defendant being is hereby sentenced to the Correctional Reception Center or in Ohio for a period of 18 months as to count 1 and to 9 months as to count 3. Those sentences are ordered to be served consecutively to one another. Based upon the joint recommendation, also the court finds that they were committed as part of one course of conduct, and that one single prison term would not adequately reflect the seriousness of the offense. The harm caused, and the sentences that are being imposed are not disproportionate to the harm caused. And also the defendant's extensive criminal history does warrant a consecutive sentence for the protection of the public. Now, according to the records, you were arrested on the 15th of December on this charge, is that correct?
My service is 15 or 12.
According to the records here, it's the 15th. So court will give you 36 days of credit.
Actually, I was brought to Highland County on the 15th. I was actually arrested in November.
Where were you from November till then?
I was in jail.
Where?
Justice Center. Hamilton County Justice Center.
Okay, and why were you held down there?
I was going from a sober living house. I went from the sober living house in Columbus to my sister to grab more clothes, go back to sober living house. I had a weekend pass, and I was pulled over, arrested.
And were you held in, why were you held that long before you came up to Highland County?
Because I gave them a false name.
Oh, so they had other charges on you?
Yeah, but which got dropped.
Okay, well, they were dropped and then you were brought up here?
Yeah.
All right, well, then they were holding you down there on their charges, not ours, because we didn't get you till the 15th. So your credit will be from the 15th of December. Now, upon completion of the prison term, the Adult Parole Authority may decide to put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can, but it's up to them. If they do, you'll be supervised by a parole officer under the terms they set, and if they determine that you fail to comply, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term, which in this case, half would be 13.5 months for all violations. But if you commit a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time was left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively, sentenced in a new case. The court will not impose any fine or driving suspension as to count 3. Now, you're also ordered to pay the court costs for judgment, grant, execution order. If you don't do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, but once you get out, you could be permitted to do community service in this county and be given credit for each hour you work, and an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Is the jail time credit 37 days, Your Honor?
36.
36?
Yeah. All right, anything further?
No, Your Honor.
All right, you're remanded to custody then, Mr. Scholler. Thank you. right, this is case number 22 CR 146, State of Ohio versus Donald McKenzie. Mr. McKenzie, you're Donald McKenzie appearing there from the jail with Mr. Wagner.
That is correct, Your Honor.
All right, and appearing from the prosecutor's office is Mr. King. This hearing is being conducted by Zoom. And Mr. Wagner, you and your client agreeing to this matter being conducted by Zoom rather than his personal appearance in the courtroom?
We are, sir.
You all right with that, Mr. McKenzie?
Yes, sir.
All right, Mr. McKenzie was arraigned earlier this week on a charge of aggravated possession of methamphetamine, a third-degree felony. He's in federal custody and was removed from there pursuant to a federal writ, a habeas corpus, to be brought before the court here for this charge. The matter was set for trial and scheduling order was issued, and then the court was informed yesterday afternoon that there would be a plea hearing this morning, and I have received a copy, signed by Mr. King originally, and then with fax copy of the other signatures that indicates, Mr. McKenzie, that you're going to plead guilty to the charge. And I'll hold this up to the camera just so you can confirm that that is a plea agreement you saw.
It is, Your Honor. Thank you.
All right, and then on page 3, there is a sentence that says, I enter this plea voluntarily. Right below that is there's a line for signature defendant, and is that your signature right there immediately below that line?
It is, Your Honor.
And when did you sign this agreement, Mr. McKenzie?
This morning, Your Honor.
All right, and when you signed it, did you understand that it was an agreement to plead guilty, there wouldn't be a trial, the next step would be a sentencing?
Yes, sir.
And you went over this with your attorney before you signed it?
Yes, sir.
And you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
I mean, you've only been in here for a few days, but you've had enough time to go over this to your satisfaction with Mr. Wagner?
Yes, sir.
All right. So you don't feel you've been rushed or pressured in any way?
No, sir.
And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
Now, the agreement states you're going to plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, a third-degree felony. Further states that you understand that the maximum prison term for that could be 36 months, the minimum is 9, and there's different levels in between. There's a fine of up to $10,000 and a possible license suspension of 6 months to 5 years, and there's a presumption prison term should be imposed, although it's not mandatory. Do you understand that?
Yes, sir.
And now, other than the federal charge that you're serving now, sentence you're serving now, Mr. McKenzie, are you facing any other felony charges besides this one?
No, sir.
And are you on community control or probation for any other charges?
No, sir. It's
All
a
right.
federal thing.
All right. And you're not on the PRC for any previous conviction? Okay.
No, sir.
All right. Now, under the law, Mr. McKenzie, if you are convicted and sentenced to prison on this charge, once you serve it, the prison term, it is possible the Adult Parole Authority would put you under PRC for post-release control for a period of up to 2 years. They don't have to, but they could. But if they do, you'd be supervised by a parole officer in the terms they set. And if they determine that you have failed to comply, they could return you to prison, make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half whatever prison term is imposed for all violations. However, if there's a new felony committed while under post-release control, then in addition, whatever sentence a judge in that new case could impose, that judge could also sentence you for committing that new offense while under post-release control, in this case, to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater, and that would be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, as I indicated, there's a presumption there should be prison term imposed, but it's not mandatory. So under the law, it is possible that the court could sentence you to community control or probation for this offense rather than prison. And that means you'd be supervised by a probation officer under terms set by the court. And if during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court, serve a copy on you, there would be a hearing, you'd be entitled to have an attorney at that hearing. If the outcome of the hearing was that you'd failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for 36 months, fine you $10,000. Do you understand that?
Yes, sir.
All right, now the charge in this case alleges that on or about July 28, 2021, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in an amount equal to or exceeding bulk amount, but less than 5 times bulk amount. So that's the charge, a third-degree felony I just described for you earlier. Now, Mr. McKenzie, you understand the charge and possible penalties?
Yes, sir.
And you understand what the state is accusing you of having done, when, where, and how they allege you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
I have, Your Honor.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
And again, you're okay with going ahead and moving forward quickly in this case without
Correct, Your Honor.
further proceedings? Okay.
Correct, Your Honor.
All right. Now, are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threat been made to get you to plead guilty here today?
No, sir.
Now, the agreement states on page 2 the following language is printed in bold and underlined. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend 9 months incarceration consecutive to the federal term of incarceration defendant is currently serving. Is that your understanding of the agreement?
It is, Your Honor.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir, Your Honor.
Now, do you hold any license or certification from any state and governmental agency that regulates any occupation or profession in this state?
No, sir.
Right now, you have certain constitutional rights, you must understand, before I can accept your plea. Now, you do have right to counsel, and I appointed Mr. Wagner to represent you. That appointment wasn't simply to work the case out, but provide any defense that might be available to you under the law that you would like him to provide. So if you decide you don't want to do this, you want to defend the charge, then he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, Mr. McKenzie, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented, they'd be instructed under the law, and then that jury would have to decide by unanimous verdict, meaning all 12 have to agree, as to whether the state proves your guilt on the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
Right now, under the Constitution, Mr. McKenzie, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor was done asking questions, your attorney would ask questions. That's cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify for you, same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request, the court issues a court order, it's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir, I do.
Now, under the Constitution, Mr. McKenzie, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury, because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir, I do.
All right, now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to prove you're not guilty simply because you've been accused. The fact at trial, you don't have to put on any evidence in your own defense. You can, but you're not required to. But whether you do or not, the burden of proof remains upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, Mr. McKenzie, you originally entered a plea of not guilty to the charge. That plea denied the allegation, and the indictment denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits it as a crime, that you committed that crime, and that plea waives, gives up all the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. but without exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state, would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It would subject you to being sentenced immediately by the court, and it would also waive or give up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under certain circumstances, you could file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen, Mr. McKenzie?
Yes, sir.
All right. Now, do you have now, do you have any questions about the charge or the possible penalty?
Not at this time, Your Honor.
You understand?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yes, sir, I believe so.
You have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter a plea of guilty here today?
No, I don't have any questions.
You understand? Okay.
Yes, sir.
Now, is there anything you'd like to speak to Mr. Wagner about before we go any further?
No, I believe we covered it, Your Honor. Thank you.
All right. You have any questions at all?
No, sir.
Then is it your decision, Mr. McKenzie, to go forward in accordance with the plea agreement and plead guilty to the charge?
Yes, sir.
Then as to count one, which alleges that on or about July 28, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code, to charge of aggravated possession of methamphetamine, a third-degree felony that has a possible penalty of between 9 and 36 months in the increments provided by law in prison, a fine of up to $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Yes, sir.
All right, the court finds that on this day in open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. Pleas accepted and ordered filed. The defendant is found guilty of count one. Now, since Mr. McKenzie is in custody in federal prison, and we have him temporarily, there's an agreed recommendation, and the court is familiar with Mr. McKenzie's previous history from the review of the bill of or the discovery that the state filed yesterday. In this case, the court will go ahead and proceed with sentencing. All right, anything from the state?
Only was contained in the plea agreement, Your Honor.
Mr. Wagner?
Yes, sir, Your Honor. We would ask the court to file the recommendation. I guess boiling this down, just basic, my perception of the case, Your Honor. Again, Donald was just brought back here Monday. I got out to see him over the weekend. And I was expecting him, I was anticipating, and I don't know why, maybe just his prior actions, a difficult case. He's been the exact opposite, Your Honor. He's been nothing but cooperative, polite to me. He addressed me, Mr. Wagner, yes, sir, no, sir. From the moment we had the arraignment to the time I got discovery, which I believe was yesterday, we came out, or the day before, we reviewed it. We've gone over potential issues, Fourth Amendment, search and seizure, pat downs and everything. Not once has he indicated, hey, file a motion, let's waste their time. It was always, JD, I did it, let's get this over with. And that's where we've gone here today, Your Honor. I've reached out to his federal attorney. He's aware of what's happening here today. Donnie's out roughly, it's May of 25, Your Honor. I will call his federal attorney when I leave here. They said they would put in ever what motions necessary to get him back, or if he's released from your court to the feds.
He'll be conveyed back by our sheriff's department because that was the order from the federal court. So as soon as we're done with him, we take him back.
I guess just boiling it down, Your Honor, maybe Donnie's realized he's too old for this. It's handy, but again, he's been more than respectful of me, Your Honor.
All right, thank you. Mr. McKenzie, anything you'd like to say?
I'd just like to thank everybody for, their time and efforts to try and hurry up and dispose of this in a timely manner. And I'm sorry to, cause any inconvenience for anyone, but I am grateful. And I don't go home until 25 on the federal case right now as it stands, so, you know, I would please, you know, request or ask, you know what I mean, beg for mercy of the court, I guess, to go along with the plea agreement if you would, please, Your Honor. And, you know, thank you again.
All right. Well, the court does note that this case has been handled very expeditiously. Mr. McKenzie has been cooperative, so the court does take that in consideration. So it's a judgment order of the court. Defendant B is hereby sentenced to a term of 9 months at Correctional Reception Center, Orion, Ohio. That sentence is ordered to be served consecutively to the time sentence currently being served in federal prison. And so upon completion of the federal term, he would be conveyed to the institution. Now, Mr. McKenzie, in case there's a mix-up, like there was the last time, where they let you go without recognizing our holder or letting us know, apparently, to come pick you up, you would be required to report to the Sheriff's Department in the event that that happens. Now, the Sheriff's Department should go ahead and get that holder placed on you in federal custody so that when you're ready to be released, they can go get you. But in case it happens, you know, we don't want you walking around, you know, and then get arrested again, because that's what will happen, okay? And that one wasn't your fault, because, you know, they shouldn't have let you out. They came and got you from us. When they were done with you, they should have brought you back like we are going to do for them. But that's the way the federal government treats us, you know, like the poor stepchild. So, in any event, is there a deputy there in the room with you?
No, he won't get my driver.
I was just going to see, I think they'll probably want to take him back Monday. I know he can't get back today because it's a long trip. So what I'm just trying to figure out the time to give him credit for. He's got 7 days, so you got back on the taken out on the 13th, Mr. McKenzie, a week ago, Monday? Or a week ago Friday, yeah, last Friday, okay. So I'm going to assume that they're going to take you back Monday, but Mr. Wagner, if you would let them know, if that's not the case, I can just change it. So that would be the 30th, so that would mean, or not the 30th, the 23rd. So that would add 3 more days, so that would be 10 days. Because I don't believe they'll give you credit in the federal sentence for the time you were here. So I want to make sure you don't get cheated out of that. So I'm going to give him 10 days, Mr. Wagner, assuming he goes back Monday. If he doesn't, we'll go ahead and add another day to that, or whatever time it takes to keep him here.
If I may, they don't know, they said sometime next week, they just don't know the date yet.
Okay, all right. Well, if you would tell them to notify me when they're going to do that, and we can put on an additional entry to give additional credit once he goes. I'm going to go ahead and credit him through Monday, which is 10 days. Now, upon completion of the prison term, Mr. McKenzie, it is possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they could. They don't. The court doesn't have anything to do with that. If they do, you'll be supervised on the terms they set, and if during that period of time you should commit a violation of those terms, they could return you to prison and make you serve an additional period of up to half of the prison term that's been imposed, or 4.5 months, for one or more violations. But if you are convicted of a new felony while under post-release control, then in addition, whatever sentence can be imposed by the judge in that case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that happens, that would be served consecutively as sentence in a new case. You're also ordered to pay the court costs, which judge will grant and execute his order. All right. Is there anything further from counsel?
Just the reason for imposing the consecutive sentence, Your Honor.
Well, you know, I'm not sure that applies because that's a federal sentence, but I'll go ahead and make those findings that this is a different course of conduct, and for the term he's currently serving, is a different prosecuting authority, and the history of criminal conduct demonstrates that that's necessary for the protection of the public, and the harm that was caused in this case would not be recognized in the service of the sentence for the federal court, and the sentence being imposed is not disproportionate to the seriousness and the harm of the offense. But thank you for bringing that up. Good idea. All right. Anything further, counsel?
No, Your Honor.
All right. You'll be remanded back to custody, Mr. McKenzie. Thank you.